Senate Regulated Industries Committee to order. I see some people are still signing up on the sheets, and so continue to do that. We'll have a sheet for each of the three bills we're considering today. I'm going to give us about another minute or so for anybody that hadn't signed up to sign up. We have a 2-hour meeting. We have three bills. We should have sufficient time, but I will be mindful that we want to hear all three of these bills. Probably won't take action on the third bill, but we plan to allow any motions to move or not move a bill to be heard on these first two. Senator Huffstadler, you're going to be up. Okay. You're welcome to stay in that seat, or you can go to the podium, whichever one you want. I'm going to give them another minute or two to finish signing up. We got a couple of committee members that are in the Veteran Affairs meeting that should join us here pretty quickly. While we're waiting, let me remind committee members our committee dinner is tomorrow night. I need you to RSVP to Paige McKenna, my administrative assistant, to let her know if you're coming or if you're not, so we can get a good head count. We got so far 18 different sponsors that have agreed to come join us and have a little social time, get to know each other on a personal basis. So try to remember to let Paige know if you are coming or if you're not coming. All right, I'll recognize you, Senator Huffstadler. We are working on Senate Bill 34. You have a committee sub you presented to me last week. I can only tell a couple of words changed, but we're working off of LC 550460S. Committee members, there is also in your folder a proposed amendment from Senator Summers that is a proposed amendment to this sub, and I will summarize it briefly as I understand it. Nick Tate will be here, our legislative council member or assistant to this committee, can explain in more detail, but as I understand it, it is to make the rules changes, the substantive policy in the committee sub before you apply to all electric suppliers, which would include EMCs and municipalities and MEAGs, as well as Georgia Power, so it's sort of an even playing field for all electric suppliers. Anybody speaking to the bill, feel free to give your thoughts on whether this should apply just to Georgia Power or to all electric suppliers or to none of them. There are copies of Senator Summers' amendment next to my good friend Senator Lucas here if anybody wants just to see it, but it's legal mumbo jumbo that says what I just said. All right, Senator Huffstadler, if you would present your bill. I know you gave us a once-over on it before. We've taken a good bit of public comment on it. It looks to be another 6 or 7 at least people that would like to be heard today. That happens sometimes as bills sort of percolate through the system and get publicity and get attention drawn to them. So we may have people here today that have not spoken before. I'm going to try to give new speakers a opportunity to speak before people that have already been heard on this. If you would start by explaining to us the changes in your bill and just the general purpose, what you're attempting to accomplish here, and we'll allow the committee members to question you, and then we'll start listening to speakers. So floor is yours.
All right, and this is the same bill that we presented at the last meeting.
You showed the sub at the last meeting?
Yeah.
Okay, I wasn't positive when that came to me.
Pardon?
I wasn't positive when you brought that sub.
Yeah,
so
we had at the last meeting, it was just a couple of words changed, substantial being taken out, like you said.
Okay.
And I'll be brief here because we have gone over this and save time if I need to make comments then. But Senate Bill 34 is a short bill. It says one thing: any electricity cost incurred because of data centers will be paid by the data centers and not by the residential and small business customers. It doesn't set the rates or get involved in setting the rates, but it does codify into law that those responsible for the cost will pay for the cost. Well, since the last meeting, I did meet with the PSC staff and the chairman. I expressed my concerns that the ruling from the PSC left it totally at Georgia Power's discretion. They stated they wanted to get something out quick and that it was only a first step, and I think that's fair, and I think the chairman that I met with has similar interest on where the cost should go, but I want something in place that doesn't let history repeat itself, and the legislature certainly has a responsibility to help protect its citizens. The legislature created the Public Service Commission. We can set basic parameters and guidelines if we have the need to. You're going to hear some testimony that the ruling from the PSC is inadequate to protect our ratepayers. And if we all agree, and I've heard we all agree, that the residential ratepayers should not incur costs from data centers, then no one should have a problem with this bill. Thank you to the committee for your consideration. I hope you'll pass this important piece of legislation for the ratepayers of Georgia.
Anybody have questions for Chairman Huffstetler? Senator Lucas, you're recognized. I think you're Mike 12.
Senator, can you show me emphatically where the data centers have been placed on the customer's utility bill?
Well, going backwards, I would say one thing is we've been told that the data centers, and this has been statements from the PSC themselves, are going to take up the power of the additional Plant Vogtle, which is about 1,000 megawatts. I think it's 1,024. In addition, they're adding 3,400 more. So the ratepayers had a surcharge from 2011, I believe, till just recently that paid for the profit, the taxes on the profit, some interest. In addition, they have a 60-year mortgage set into their base rates to pay for this. So I would say, and I'm not really trying to look backwards as much as forwards, but I would say backwards, it looks like they're going to be benefiting from what the ratepayers have in their charges right now. We've of course had 6 rate increases in less than 2 years. My biggest interest is this 3,400 going forward, that we codify into law that they won't be charged anything for those.
But can you show me emphatically where data centers have been billed to the ratepayer?
You look at the rate they're paying right now, which is a fraction of the consumer's rates. The consumers are paying for this power, additional power that's being consumed by the data centers.
We are paying for that. We are paying for Plant Vogtle.
Right, and who's going to benefit from it is the data centers. And I'm not opposed to data centers. I welcome them to Georgia, but that would be the past, and I don't want history to repeat itself. So I want to make sure we codify into law that that this won't happen in the future.
Are you familiar with the term CWIP?
CWIP.
Yeah.
I know it's an acronym that's used.
It stands for Construction Work in Progress, which we used to pay for.
Right.
And we ended up not doing it. And then, of course, in its infinite wisdom, the legislature kind of gave that up. And so we get charged for things like Plant Vogel. Contractor went bankrupt. Georgia Power ate that up, but that was part of their profit. And so what I'm asking you, can we emphatically show that data centers that Georgia Power are funding is in the customer's utility bill?
The customers, I'll try to say this again, the customers are paying for the capital cost of electricity that's being used by data centers coming into the state, who are paying a fraction of the price.
Senator, did the Public Service Commission recognize that and in their most recent rulings or regulations attempt to recoup the cost of generating electricity and transmitting it from data centers or other large load?
I don't think it's recouping. I think it's more going forward that they're going to look at that, and I'm looking at forward as well. But I do think that if you look at the past, it's certainly going on right now.
And their most recent plan, does it project that they're going to need significantly more power production to feed the needs of Georgians, including these large users?
Right. In addition to the 1,000 megawatts from Plant Vogel, they say they need another 3,400 megawatts of power.
Okay.
So almost 3.5 times as much.
So they're going to have to build more capacity.
Mm-hmm.
All right. Any other senators on the committee have questions for Senator Huffstetler before we have public comment? All right. Thank you. If you will stay here at the witness chair so we can have you handy. We'll begin with old law school classmate of mine, Robert Baker, the first, Bobby Baker, we called him in the day, the first Republican member of the Public Service Commission, if I recall correct. You may. He was he didn't run with the crowd I did. He was in the library. I was supporting the Georgia Bulldogs.
We were in different sections, so we didn't have the same classes together. Thank you, Senator. Thank you, senators, for allowing me to speak here, and thank you for Senator Huffstetler for inviting me here today. My comments today will focus on my review of Georgia Power Company's recent rule changes regarding new large load customers and why Senate Bill 34 should be passed. I served on the PSC for 18 years and have been practicing before the PSC for the past 15 years. The recent rule changes approved by the Public Service Commission at their January 23rd, 2025 administrative session provides no guaranteed protection for ratepayers, but instead are full of loopholes that you could drive a truck through. Additionally, the rules can be changed at any time within 30 days by Georgia Power, at Georgia Power's request or at the PSC's own initiative. Now, the first rule change was to Georgia Power Company's General Rules, Section A, Paragraph 1. It says that the company may require additional terms and conditions of electric service, including without limitation minimum billing requirements and a longer term of contract when the company deems it appropriate. To ensure the company recovers all costs associated with servicing or preparing to serve a customer with an expected peak demand of 100 megawatts or greater at one or more premises. Now, the rule change does not mandate or require Georgia Power to impose any additional contract terms or conditions upon a new large load customer, but gives the company the complete discretion to do so. The second set of rule changes are to the rules and regulations for electric service, Section D, paragraphs 2, 13, and 14.
Before you go there, on that first rule you just mentioned, the
Yes.
maze, how does this statute change that?
How does that statute
How does
change
this
that?
proposed bill change that rule that was passed back in the fall?
It's going to eliminate the discretion on the part of the company whether they make any changes or not.
Changes a shall to a may, a may to a shall?
I don't think it says in the bill shall, but the intent in the way it would be interpreted probably would eliminate the discretionary aspect of these PSC rules.
So those costs must be considered in setting the rate?
Yes.
Okay. Does it allow flexibility for the Public Service Commission to have further additional rules and rates and regulations in the world of large capacity users?
I believe so, yes.
This sets a floor, but not a fixed
It-
solution.
It's basically setting out a policy statement that the cost causers need to pay for the costs they cause.
Okay. All right, go ahead.
Okay,
I just
all right.
want to make sure we understood. what
Sure,
we're
now,
doing
now
here.
please ask any questions you have. The second set of rule changes are to the rules and regulations, paragraphs 2, 13, and 14. In 2, paragraph 2, the company makes additional terms and conditions discretionary and provides if additional terms are, quote, deemed appropriate by the company to ensure if it recovers all costs associated with servicing or preparing to serve a customer. Paragraph 13 states the company may require additional performance and credit provisions it deems appropriate to protect the company and ensure the recovery of cost. The new provisions of paragraph 13 are discretionary or optional based upon the company's judgment, and it makes no mention of protecting existing ratepayers, but instead it emphasizes protecting the company. If the company determines it can recover the additional costs from other sources or ratepayers, there's no mandate requiring that the new performance or credit provisions on new large load customers be enacted. Paragraph 14 deals with the recovery of costs incurred to serve the large load customer at the termination of their contract for service. Once again, the rule change contains discretionary language, may be required, and allows the company complete flexibility whether to recover any costs from the large load customer. These rule changes are essentially worthless because of the numerous loopholes that they contain. None of the rules changes offer any guaranteed protection to existing ratepayers and do not require Georgia Power to impose additional costs, terms, or conditions upon service to new large load customers to guarantee the additional cost incurred to serve them are recovered from them.
Now, everything you've told us so far, that's not statutory. That's a PSC rule.
That is a PSC rule submitted to, that was approved January 23rd,
So that's-
2025.
Okay. Up until that rule, was there any such imposition of recovery of cost?
Nothing specific that I'm aware of.
All right. And are you aware or have any knowledge about the exceptional power needs of these large data centers or big power users?
I do, and they do use an enormous amount of power. Georgia Power is used to dealing with increase in demand of 100 megawatts a year, 100 megawatts a year. You're talking now about thousands. And we have more than adequate generation right now to serve all customers in the state of Georgia. And what is going to happen if these new large load customers come in is that there's going to have to be provision made for new sources of large load generation, huge amounts of generation. I mean, you're talking about billions of dollars more in capital expenditures. And the problem is that a lot of the rate system is set up so that you and I, we're on base rates as residential customers. We pay base rates. Our average rate right now is about 21 cents a kilowatt. If you're a large industrial customer or a large load customer, you can get on what is called a marginal rate. It's a great deal. It's wonderful. You're paying a fraction of what base rates are. You have to be interruptible, but you get it. It's 21 cents to 5 cents. That's the differential. And if you're an industrial customer, it makes sense. Would you want to pay 21 cents or 5 cents? It doesn't take a rocket science to figure that out. But bottom line is, what is worse about these rule changes is that they can be amended or dropped entirely within 30 days at the request of Georgia Power or on the Commission's initiative pursuant to OCGA 46-2-25. Senate Bill 34 is needed to make sure rate protections are put in place that can be changed and not changed in 30 days by 3 commissioners. Georgia ratepayers need the protection provided by Senate Bill 34, and I'd ask you to support Senate Bill 34. If you have any questions, I'll be glad to try to answer
Probably
them.
going to have a few. Given your experience on the Public Service Commission, will you just give my committee a real brief primer on the Territorial Service Act and the difference between the large use or large load customers and your general residential or commercial customers?
Georgia has a statute that was passed back in 1975 called the Territorial Act, Territorial Service Act for Electric Service. It's unique in the United States in that we have had electric competition to a limited extent since 1975. If you're a large load, a new large load customer has a new connected load of 900 kW, not even a megawatt, 900 kW, when you are proposing your project, a factory, a shopping center, it has to be a single metered connection, can basically shop. You can shop in Georgia. You can shop with EMCs, Georgia Power, MEAG. You can look for the best deal out there for your electric service. It's a one-time option, and it's only for new large load customers. It's a great deal. And a lot of these data centers and new large load customers, they're going to take advantage of it. They're going to shop it. They're probably going to prefer Georgia Power just because of the size of the company, their reputation, their reliability. But if you're a new large load customer, it's a great option in Georgia to have to be able to shop around and get the best deal you can negotiate.
Senator Summers has an amendment. I don't know that you've seen it or not, but the gist of it is that this law would not only apply to Georgia Power through the PSC rule essentially being codified, but they'd create a new code section that would require any other electricity supplier to be subject to the same conditions. And I think his point is that because the EMCs can be competing against Georgia Power for these large load data centers or other industries, that they ought to be on a level playing field or also be forced to recoup those costs and distribution costs. Do you have thoughts about that or observation about that?
Just a quick observation based on the information. I don't think there should be any discrimination.
All right.
I don't.
Committee members, anybody have a question for Mr. Baker? All right, I'm going to start with you, Majority Leader Gooch.
Mr. Baker, thank you for being here. It's a pleasure to see you. I have an example on customer choice. In Dahlonega, we built a hospital. 2 years ago, it opened. The hospital area where the hospital was built was currently being served by Georgia Power. However, Jackson EMC was the customer of choice, or there was the customer's choice to provide the electricity. So Jackson EMC had to build the power lines over to the hospital, which was several miles away. Who pays for that upgrade for that power line? Because the Georgia Power lines were already on the property where the hospital was being constructed. But Jackson EMC had to bring the power line to the hospital. So in that situation, who would pay for that upgrade for that utility for Jackson EMC?
New transmission lines were built to already existing.
It's not a transmission line, it's a service line, but it was a three-phase power line. So it was a significant investment of money for 2 or 3 miles. And I'm not picking on either side, I'm just trying to learn, because we're talking about an issue with only data centers, but I wonder how that compares to a hospital or a commercial development.
Senator, I'm not familiar with the facts of that case, but normally what happens is, yes, that's an example of how there can be competition. Yes, there's a lot of back and forth. If this hospital was originally served by Georgia Power, they're not going to give that up voluntarily.
It was a brand new hospital.
A brand new hospital, okay. So in that case, in that particular case, knowing nothing but what you're telling me, is that might have been included in the cost to the hospital of, if it's a distribution line now, distribution, not transmission. If it's distribution, the hospital may have had to pick up that cost, but if they got, if you'll pay, a few $100,000 or $1 million if you can save $10 million.
Sure.
I mean, that's just
But would
good
the-
business, good economics.
Would the power company pay for that extension of that line if they knew they had a long-term customer there and they would make the money back in a 5 or 10-year time frame?
You can do it, yes. They're not going to give it away, but they're probably going to build the capital costs of building that distribution into the rates that the hospital got. If they were a new large load customer, it's a contract. You build it into the rates. They're not out to lose money. They're out to make a
So,
profit.
I'm not trying to put words in your mouth, but it sounds like we're carving out data centers only when there's other examples of where commercial customers are doing the same thing, but the power companies are paying for the upgrades to service those customers. Am I clear on what this bill does?
It depends. In these cases of, you know, in this bill, I think it specifically says large load customers. It doesn't say data centers. Unless there's been a change that I haven't seen, the more recent change. More recent change? Okay.
I think it specifies data centers.
Okay, all right. The costs are, you know, like I say, if they're coming in, if they're shopping their electric service provider, it's a very competitive. It's a business deal. It's business negotiations. You're talking about huge amounts of money for capital expenditures. Georgia Power has to build huge transformer stations to service these large load customers. And that's tens of millions of dollars or more in cost right there just to build the transformer station to serve a new customer. And normally they're trying to get, they don't share anything with me as far as how they negotiate or their contract terms, but they're going to try to get that new customer to cover the cost for some of those expenditures that they have to go out of pocket. And there's no guarantee that they're going to be around for 10 years, 20 years. I mean, we're seeing right now the whole transformation in the AI industry with, was it DeepSeek or whatever it is, how it's just transformed the AI industry. And all these data centers are, a lot of them are spec projects, pure spec projects, unless they've got a Amazon, Google, or, you know, being built by them. A lot of these are spec projects, and they're looking for prospective customers to use their facilities. And there's no guarantee they're going to be around in 5 years, 10 years, 20 years. But we're going to be here. We're going to be paying.
Senator Kennedy, you're recognized for question, then you, Senator, again.
Thank you, Mr. Chairman. Thank you, Mr. Baker, for being with us. And thank you for walking us through your analysis of the PSC's new internal regs on this issue. We don't have those in front of us, so I couldn't follow, but I think I understood.
I have a copy if you'd like a copy.
Okay. I think I understood the points you're making. You described them as loopholes. My question is, assuming that Georgia Power wants to fully employ the concept of passing along these additional costs, how long would it take for that to happen? What would you expect that process to look like, and how long would it be before they logistically could actually employ that concept as embodied in these new regulations?
Well, first, the new generation has to be built. So right now if anybody's familiar with Plant Yates, they're planning to build 3 combustion turbine units up there that'll cost a couple $2 billion. Those costs, those plants are still under construction. They probably won't come into be operational until late 2026, maybe early 2027. At that time, then, those costs for those 3 new plants and for the other investments that are being made for battery storage, large-scale battery storage, would then be put into rate base. We're about to start a rate case this summer. Now, are those Plant Yates costs going to be included? No, because those plants aren't even built yet. I don't know where they are, but it's going to take a while for them to be built. Now, there are other costs that have been incurred from buying power from out of state, from Mississippi Power and from another power generator. Those costs are being recovered.
So it sounds like some 2 to 3 years, maybe you mentioned 26, 27, something like that.
I'm sure Georgia Power could tell you exactly when those combustion turbines at Plant Yates will be operational and then can be included into rate base, but I don't know.
We got
So-
Eric Mitchell coming up shortly. You can ask him
Okay.
that as well.
All right. So, Mr. Baker, so the purpose of my question really was to, and maybe I'll ask the question of someone else, is if Georgia Power wanted to utilize the new regulations, which you said were January 23rd, so about 30 days ago, in a way fully, as I think you're contemplating that this bill would do, they wouldn't be able to do it, and we wouldn't know it or see it for a few years. So we're really too soon to know whether or not they're going to align themselves with what you think ought to be done or not. Fair?
Sort of fair, but if these rules are in place, it's all discretionary. They don't have to do it. The language leaves huge loopholes, and they can either negotiate with these new prospective customers, and they're doing those negotiations now. They don't wait till the data center or whatever is built. They start now. And in fact, they started months ago to begin the negotiations because of the contracts, bidding for electric service providers. So these loopholes in the rules that can be changed in less than 30 days don't provide any type of real reliable protection for existing ratepayers. That's my point. That's what I'm trying to say right now. And that's why Senate Bill 34 gives it a little bit more guaranteed protection prospectively for those future costs. When they come, when those plants are built and they come into rate base, that those costs will be borne by the large load customers that created those costs. We've got the power we need right now. The demand is just astronomical. It's just unbelievable. The amount of power that they claim that could be demanding is in 8,200 compared to 100 every for the past 20 years. That's just crazy. That's just crazy. And who's going to pay for that? That's the question. Who's going to pay for that? At 21 cents a kilowatt right now, that is historical highs. We've had 37% rate increases since March of 2023, and there's no end in sight. No end in sight for the average ratepayer. I mean, ratepayers can't get the marginal rates. I can't get a marginal rate. I'd love to pay a nickel a kilowatt. I think that'd be great. I don't. And that's the point I'm making.
Senator Ginn, you're recognized for a question.
Thank you, Mr. Chairman. If I can, I want to ask you a couple quick questions.
All right, let's keep it to 2 or 3.
Said you took an economics class somewhere in your history. You learned about widgets. Said they always told me if we can make more widgets, then we can make them cheaper. You agree with that?
No.
You don't?
No.
Okay.
No, I'll give you a perfect example.
Well,
We've got in Georgia the major widget machine at Vogtle, the United States' most expensive generator of electric power, and probably in the world. That's the most expensive in the world. I think there's only 1 or 2 facilities that are more expensive than the Vogtle 3 and 4.
I was glad I wasn't here when they decided to build 3 and 4 on Vogtle. Said I don't think most of my colleagues were here. Said and that's where, when I look at it, as we continue to make more widgets, the common theory is that the widgets will get cheaper. Data centers are a continuous load. They run 24/7, 365 days a year when they get in operation, until they don't. I appreciate your service on the Public Service Commission for the years that you were there. And one of the things that I guess when I look at it, you made rules and regulations. You used to talk about how quickly, in 30 days and 3 commissioners, you can change that. How were you elected to the PSC?
By Georgia voters.
Georgia voters. Do you think those Georgia voters are going to keep people on the PSC that aren't protecting their utility rates? And would they, is there a method or a reason why those people that are elected on the PSC and given their role, to regulate the regulated utility, Georgia Power, then why is it that you want the legislature to get out of our lane and force just for data centers, not anybody else, but here's a load that runs 24/7. Why do you think that we should go get in front of the voters with the Public Service Commission? They can respond much faster to these questions.
You know, I would love to have an opportunity to vote for a public service commissioner, but I haven't had that right to vote for a public service commissioner since November of 2022. We've got 3 seats being held, one by a commissioner who's never been elected to anything. Anything.
It's coming.
Oh, when? You know, when?
Well, you keep,
I mean,
keep the lawsuits down,
it never happened in Georgia history. It has never happened in Georgia history that this kind of thing has happened where you have constitutional officers that have not been elected for 3 years. It's just unreal, unreal. And if you can't hold them accountable, find somebody else.
Any other senators have questions for Mr. Baker? All right, thank you. Now, let's be respectful of our folks testifying for and against. I have 16 people signed up to speak, and all but one have identified themselves as in favor. I don't have, Mr. Bond didn't say which side he's on from the PSC, but let me first recognize Mr. Aaron Mitchell. He spoke to us recently from Georgia Power, so let's hear their side. Then I'm going to call on Mr. Tom Bond from the Public Service Commission. Then I'm going to hit a few of the others. I know a lot of you made efforts to be here. We'd like to hear from you, but we do have a limited time period. All right, Mr. Mitchell, if you'll identify yourself and give us your thoughts on this committee sub and the proposed amendment.
Yes, sir. Thank you, Mr. Chairman and members of the committee. My name is Aaron Mitchell. I am Vice President of Pricing and Planning for Georgia Power. My team is responsible for planning to meet the energy needs of the state and our customers for the next 20 years, as well as ensuring that the prices that we charge are appropriate for recovering the costs that we incur to serve each and every customer. I'd like to start, if I may, by providing some clarity and some corrections on some statements maybe that were made earlier. In reference to the 3,300, it's 3,300 megawatts of new generation that were approved by the Public Service Commission last year. Those megawatts will be online by the end of 2027 to meet our customers' needs beginning in the winter of 2028. That's December through February or March of that winter period. The important point that I wanted to make related to that is we will spend capital, billions of dollars, to install those 3,300 megawatts. And we have committed that residential customers will pay nothing in excess to account for those 3,300 megawatts of new generating resources. In fact, we committed that residential customers will pay less than they were paying when the Public Service Commission approved that, because we are able to install that new capacity and serve additional load to the effect of $2.89 less in downward pressure on rates, because we are able to serve a growing system and a growing number of Georgians, a growing number of businesses. The more that we are able to serve, the more that we can provide benefits to existing customers by virtue of those new customers coming online and paying their fair share of the costs that we incur to serve those customers. I think that's a really important point for this committee to hear, in that we not only are growing our system, Georgia Power's made a commitment to provide downward pressure on rates because we're growing our system, and the Public Service Commission has ordered us to provide that downward pressure on rates related to that 3,300 megawatts of increased growth that we are about building right now. Related to pricing for large customers are different in that they are large. They are not different in that the pricing fundamentals of all utilities in this state and throughout the country is that the price that is offered through the rates for any customer must ensure, especially for these large customers because the investments are large, must ensure that we're recovering revenue from those customers that exceed the costs that we incur to serve them. Georgia Power and no other utility has any incentive to push those costs on any other customer in its system, especially residential customers. In fact, we are incentivized to do the opposite, to make sure that the prices that we are charging these customers for the large loads, for the new generation that we're adding, for the transmission that we're adding, is not only sufficient to cover the costs, but is sufficient to provide benefits to all other customers. Like I said, that downward pressure in rates.
What do you mean by the charges? You're making sure that, let's just call us residential customers, are not paying for your additional power generation and distribution costs for these big users.
Yes, sir.
Well, how do you do that then? They're not paying yet, but you're having to build new plants according to your most recent plan in order to provide power for these new customers, and that's the
right.
big new so how do you make sure that that doesn't get passed along when you're incurring the cost up front and then recouping it through your rates later?
Thank you for that question. So we incur costs to build a new combustion turbine or a new battery energy storage system or any transmission. We're not allowed to charge customers for that until that unit or that transmission asset goes in service to serve our customers. We are adding those additional assets to follow the load growth for Georgia and all of our customers, but in particular, to your question, as these large customers come online, when we have a new generator come online, that follows the needs of these large customers. We're doing things by virtue of these rules and regs changes that the Public Service Commission ordered, as well as how we recoup upfront costs from customers to ensure that those costs aren't spread to others. For example, we build local transmission or on-site substations to serve these large customers. We require 100% upfront payment from those customers before we will build that asset, and those costs do never go into the rate base and are not subject, and there's no chance that they can, be spread to other customers.
Is that mandated by PSC rules and regulations or just the good-heartedness of Georgia Power?
Well, it's both. There's been some discussion about the rules and regs and what it allows the company to do. And the flexibility provided in the rules and regulations ensure that each of these customers are different. There is no data center that is the same. They are not spec. So every data center or large customer that we serve, our engineers determine what's the transmission and generation needed, what's the cost to serve that, and the tools in the rules and regulations ensure that we can adapt and charge more or upfront as those situations arise, all to balance those costs from being shifted. While the rules and regulations provide us needed flexibility to ensure that we're charging appropriate rates, the Commission's order does not. And so I read this last time, but I'd like to read it again.
Go right ahead.
From the Commission's order filed on January 28, 2025, approving the rules and regulations. The first main bullet point states that the company shall exercise the discretion under the rules and regulations changes in a manner designed to protect existing customers from bearing any of the costs of adding these large customers. And so while the rules and regulations provide flexibility, again, the Commission's order does not, and the Commission's order carries the full force of the law.
I got one question, and I have at least two senators that have questions. Are you concerned that other electricity suppliers have a competitive advantage now against Georgia Power in bidding for the large load clients or data centers under that new rule and regulation that applies only to you and not to them? In other words, they could undercut you by not recouping those costs if they elected to.
Certainly, Mr. Chairman, I can't speak for the other utilities. But like I said, no utility is incentivized to spread costs to other customers. To your direct question, no, I'm not concerned.
Okay.
Georgia Power will not serve a customer if we cannot recoup the costs from that customer for these large loads. Our price will be our price to compete for that load. It happens every day. Each of us in our daily lives choose other providers, but we will make sure and are ordered by the commission that we can't charge them less for what it costs these large loads to be served.
Well, you may never have another large load client or data center. Then if the EMCs get wise to this and realize how much money they can get paid up front to recoup their cost, and they don't have to set their rates in accordance with this new rule and regulation.
Again, I think we are very competitive. We offer competitive rates, superior reliability, and these rules and regulations changes were Georgia Power's proposal. We started working on this in June of last year with the Public Service Commission. We want the rules and regulations to be applied because we want to protect all other customers and give some assurance beyond what we have today that we're protecting all other customers. For example, we're going to require collateral throughout the contract term such that if a company has to make a different decision and leave before our contract expires, that collateral will cover the cost of what they would have paid so that other customers do not bear the force of those costs. And
So if a data center closes down, lose their customers, and new technology makes them obsolete, you still got them
yes, sir.
locked down?
Yes, sir.
Okay.
And we believe this protects customers.
Senator Albers, I'm going to recognize you for a question. You feel free to have a follow-up, but let's don't have a long dialogue, and then Senator Dolezal.
Yeah, I'll be brief, Mr. Chairman. Thank you, and thank you to you and Sister Ward for spending some time going over some of the numbers with me.
Yes, sir.
I think part of the challenge here, because after we had that conversation, you all reported your 2024 numbers. And I think this gets back to a core of people are concerned about the rising utility rates, and if they're being driven by data centers and other things, how that's impacting the folks that we all serve. Knowing in the last few years, the average family's gone up $500 during the worst inflation we've seen since the late 70s and early 80s. $500, but you all just did $11 billion increase, and your profits increased $2.5 billion, higher than you've ever been before, 22% higher than the year before. So my concern, and I think why the author of this bill is here today doing these things, is we're not seeing that money coming back to people. And I know you said you've committed to rates going down, but commitments to us really mean nothing until it actually gets back either on people's bills or they're getting something back in the mail. Now here in Georgia, we had a record surplus. We started sending money back to people, right? They're getting $250 back per person yet again, plus we did it for property taxes. So I guess I want to know, in all of this, it's the old, hey, just trust us, we're going to do the right thing. But I'm losing a little faith based on the numbers I'm looking at right now. So help me understand, are we going to see a refund coming soon?
So thank you, Senator. You're quoting the Southern Company earnings, right? Georgia Power is a piece of Southern Company
I
and
was
contribute.
quoting the Georgia Power numbers, but keep talking.
Okay. Our profits are capped by the Public Service Commission, and any earnings above that, 80% of that goes back to customers.
Oh, great. So when are we getting our refund checks?
Any earnings for 2024
Okay.
that were above what the commission has approved, 80% of that will go back to customers. That proceeding goes before the Public Service Commission, and we'll be taking care of in a rate proceeding on how that is distributed back to customers.
All right. We don't want to get too far down the road because Chairman's
Senator
got other bills.
Dolezal, you're recognized.
Thank you. And like Chairman Albers, I want to thank you for meeting with me. You guys essentially, would you agree, have a monopoly for your residential customers. Is that accurate?
In the service territories that we and other electric providers in the state, the Territorial Act defines service areas where
So yeah,
you
I mean,
are
yes,
to, yes, for
So,
those areas.
Help me understand the logic, because I can't connect this idea that you're not incentivized to charge more for the residential customers who don't have a choice, so that you can then have lower prices to win the business of the non-residential customers that don't have a choice. It would seem to me that if you could have costs passed on to the residential customers, that would provide a vehicle then for you to be more competitive on the commercial side and really have the best of both worlds. What am I missing in not understanding the logic on that?
Well, Georgia Power doesn't have the decision on how those costs or charges are allocated. That's a decision of the Public Service Commission on what we're allowed to charge each of the customer classes based on the cost to serve those customer classes. Regardless of that, any large customer will pay their share of the costs, and they will not be passed.
So if
to
that's
any
the
other
case,
class.
why are you all here? Like, I've had more lobbyists that were, you guys have a lot of lobbyists that work for you. And I've had more of them reach out to me in the last week saying, please don't pass this. This is already taken care of. If it's already taken care of, then what's the issue?
Yeah, thank you for that question. The intent of protecting all customers is the same. We share that with the bill's author and all of you. The reason we've been talking about the rules and regulations is to illustrate that there are mechanisms and tools in place to ensure that we are growing Georgia appropriately and ensuring that these large loads pay their share and all existing customers are protected. The unintended consequences of how this bill is potentially authored is customers pay for a share and access to our system. All customers use the transmission system. As the bill is written, it could be construed that if a data center or a large load requires any change to the system, that they pay for the entirety of that asset, which means that they could be entitled to the benefits provided from that asset. So those benefits that I said earlier that we will be passing to existing customers and residential customers could be limited and provided only to the user that incurs or causes those costs to be incurred. That's the reason. The intent is the same. That's the reason, is that we don't want unintended consequences to prohibit the benefits that we have committed to, been ordered by the commission, and foresee from the growth of Georgia.
So really your issues with lines 17 and 18, which speak to this but-for language, such that a massive CapEx could be contributed to data centers, even though all of that may not be used by the data center.
That's right.
So why aren't you lobbying for pro rata language to be included in this bill that then recognizes the pro rata nature, I think, of what you're getting to, which I think is reasonable. I think we probably would all agree to that.
Yeah, our system serves all customers, and that pro rata share of what you cause on that system is allocated to you or these large customers. That's our main concern.
Okay.
All right, other senators having questions? If not, we've got several other speakers. Let me remind our audience to be respectful here. This isn't a bunch of, a play or something. We're going to applaud every good line or, cheer people on or boo people that we don't like what they say. Let's be respectful for all citizens being able to share their views. I want to hear from the Public Service Commission. Mr. Tom Bond is signed up to speak. He spoke to us last time, but now having sort of let it settle in a little bit, just to hear your perspectives, Mr. Bond. Thank you so much for being with us today.
Thank you, Chairman, committee members. My name is Tom Bond. I'm Director of Utilities at the Public Service Commission. At the previous committee meeting on this, Chairman Hufstadter mentioned that he would be meeting with Chairman Shaw to discuss the bill. As discussed at that meeting, philosophically, the PSC is 100% behind this bill, as evidenced by the change to Georgia Power Company's rules and regulations with modifications by the Commission on January 23rd, which changed the terms and conditions for these large load energy customers. In 2023, when the Commission reopened their integrated resource plan, the PSC held hearings on the tremendous energy need caused by data centers that is heading for Georgia. The rule change requests that the commission modified and approved last month as a direct result of those hearings. As discussed at the meeting of the chairman regarding SB 34, there is some concern at the commission that putting any rule into law can restrict the commission's flexibility to look at every situation on a case-by-case basis. The commission normally makes these types of decisions in an evidentiary hearing with expert testimony and weighing the evidence and making decisions that way. Although the chairman asked me to express this concern, the PSC defers to the will of the legislature on how you want to proceed with this. It's certainly within your authority, and so we will do whatever you ask us on this.
Any questions? Thank you for being here. Would you please stand by just in case we call you back up if anything
Yes.
comes in? Mr. Tony West, Americans for Prosperity.
Good afternoon, Mr. Chairman. Thank you for the opportunity to speak. It's been a long meeting already. I'm the State Director for Americans for Prosperity Georgia, here to speak in support of this bill on behalf of our activists across the state. At AFP, we support policies that increase economic growth and encourage innovation. We're excited at the new opportunities for jobs that come when businesses expand or relocate to Georgia. We're optimistic at the possibility of legislation that will protect both average Georgia ratepayers while also maintaining our high standards as the best place to do business. As Senator Albers had referenced earlier, Georgians have been really harmed by inflation these last few years, and higher energy prices have contributed to that pain in their pocketbooks. We believe it's entirely appropriate for this body to take a step like this to ensure ratepayers aren't harmed further. Thank you.
Any questions for Mr. West? Thank you for your views. Ms. Liz Coyle, Georgia Watch.
Thank you, Mr. Chairman. Commissioners, Liz Coyle, the Executive Director of Georgia Watch. We're a statewide consumer advocacy organization, and we've been intervening in matters at the Georgia Public Service Commission, rate cases and integrated resource plans and Plant Vogtle since 2010. I've been down there since 2012, so I've been through a lot of these proceedings, and I can tell you from our toll-free consumer hotline, as you all know, your constituents are struggling to pay their power bills. Now, there was some talk from Georgia Power and questions about downward pressure on rates and a couple of dollars that were in the settlement that was reached in a special, rare interim integrated resource plan when the company realized the one we just finished was not forecasting enough capacity need for these large data centers. So in that agreement, which we did enter into, because there were some good things for ratepayers. What it said was it'll put a couple dollars down pressure on rates. But what the witnesses wouldn't say in the witness stand was your constituents' power bills are going to go down by that $2. It just means it'll offset by a couple of dollars. And let me tell you, now that the company has filed the next 30-year plan, we know there are going to be a lot of costs associated with it. And once we get through that proceeding, I think you all know at the end of this year, we're going to have yet another rate case. And in all the years I've been down there at the commission for rate cases, people's power bills have not gone down. So I urge you to use the tools you have available in the law to make sure that Georgia Power's customers, and I do support the amendment that would apply this to EMCs and also the municipal electrics. Those people's power bills are going up too. And I think that that's a reasonable, and I hope, I haven't talked with Chairman Huffstetler to see if he agrees, but I think that's a reasonable amendment. And I really do hope that you all will pass SB 34 today. Thank you.
So what do you think we ought to do? Not on this bill, but as a state. We've got Georgia Power and all these EMCs that are busting their chops trying to get electricity out. We've got enormous demand. In their IRP, they've got a plan for more power, or else we're not going to have computers anymore or any internet connectivity.
Thank you, and that's really a great question. We are going to, the state is going to need to generate more power.
And that's going to cost us more money.
And right now, it looks like the data centers by far are going to be the biggest driver. As I think Mr. Baker said earlier, we don't know what's going to, I mean, we didn't expect data centers even 2 years ago. The company had to file an emergency IRP because we didn't know what was going to happen with these data centers. So one thing I can suggest to you is that the House has formed a special committee that will start meeting. I think the chair of that special committee said this summer. But they're going to be taking a really close look at the resource needs of the state entirely, but specifically as it relates to serving the resource needs of these data centers, these large load data center customers. And it's not just electric, it's water. And I don't know about you all, but my water bill's gone up too. So I think it's reasonable for this body to support Senator Huffstetler's legislation because we know the company agrees, the Public Service Commission agrees. The evidence is clear. We're going to need to find better ways to meet the state's electricity needs without continuing to harm the residential customers in this state who face some of the highest energy burden in the whole country.
So, why do you feel that that needs to be done in a statute or a code rather than delegating that to Public Service Commission, which we have historically done, and they are elected by voters to represent the consumer's interest and the business interest?
Right. Well, I'm not going to get into that question about the last time they were elected. I will say that the commissioners have been known, because they have that latitude from this body, to change their rules and change their decisions that affect the company. And I have been in proceedings specifically when the commission's own staff, folks like Tom Bond, the public interest advocacy staff that's there to look out for the residential and small business customers, but even their own advisory staff. I think that was in the last rate case when the staff did not want to settle with some of the things Georgia Power asked for in that rate case. And commissioners instead made a motion that went around the staff, negotiated directly with the company, and that was a real disadvantage for Georgia's residential ratepayers, and I was there for that.
Any questions? Senator Ginn, you're recognized.
Thank you, Mr. Chairman. Appreciate your testimony. One of the things, are you a Georgia Power customer, or you live on EMC or MEAG?
I'm a Georgia Power customer. I live in the city of Atlanta, and my office is in downtown Atlanta. So I'm executive director of a nonprofit that is served by Georgia Power, and I'm personally served by Georgia Power, as are my parents.
And
I'm senior. I'm senior.
Just so you know, at my home, I'm served by an EMC, Hard EMC. What happens with the EMCs, and I don't know, all of our members know, but they're directed by a board of directors that are elected by the members of the membership of the co-op. And this is where, for me, works really well. I mean, I get to vote for who's going to set my rates, and they're a customer as well, just like me. The amendment, you said you favor the amendment. One of the things that would scare me about putting EMCs or, and I've been a city manager for 10 years, two different cities. One of the things that those citizens get to vote for who they want representing them, and then that goes into MEAG, sit down onto the MEAG board.
Let's get to your question.
The question is when I look at this, you'd be putting another set of rule makers in if you add in the EMCs and you add in the MEAG cities into this. Does that not seem unfair that those would be, because the board of directors or the EMC, the city officials, they don't get, they've been nipped by the Public Service Commission.
A couple, thank you for that question. The Public Service Commission is, I know you know, but maybe not everybody else knows, the Public Service Commission regulates the monopoly utilities. So they regulate Georgia Power. The Public Service Commission, except in very minor cases, they don't recognize the electric member co-ops, and they don't regulate the municipal electrics. And let me tell you, people served by those other electricity providers also are facing higher power bills. They're also paying for Plant Vogtle. But one thing about this legislation is it does not mandate Georgia Power or an EMC or a Muni to serve these large load data customers. So I really don't see, given that it would be optional, it kind of levels the playing field. EMCs may say, hey, it's not fair. We might want to serve these large load customers, and this is a competitive disadvantage if Georgia Power has to follow these rules, and
If I might, the Territorial Service Act.
Hang on, I got to recognize you and light up your mic. Go ahead.
Thank you, Mr. Chairman. Said the Territorial Service Act assigns territory all over the state. And wherever a data center lands, they have a customer choice. But if they land in an EMC territory or a municipal city territory, then they're required to serve the load. Whether it's a customer choice or not, there's a default. If they land in Georgia Power's territory and nobody else wants to compete, then it's a default for Georgia Power to serve them. What worries me about the amendment that we're talking about here is this would handicap the governing authority for the MEAG cities and the EMCs, because you're putting them under the PSC as well. And currently they're not, they never have been. There's never been a situation where for rates they go back to the PSC.
Thank you for that question. And since I heard about the amendment today, I didn't see that part that it would actually put them under the PSC. What I think it does is it says that the objective of Chairman Huffstetler's legislation, and I think we've heard everybody agrees that we don't want residential customers, regular people of Georgia, subsidizing these large load data centers. And those large load data centers, as you said, they could be located in Georgia Power territory. With the Territorial Act, there's that exception. So if a large load data center can locate in Georgia Power territory, but the EMCs or the munis could bid for that. So it's just leveling the playing field as far as I can tell.
I will say that the amendment does not put them under the PSC. It has a separate code section he's calling for to make them follow the same rules. It does not set their rates in any way. They just must take into account the cost of generation and distribution of electricity to treat everybody fairly. All right, that's all the, Senator Lucas, I'll recognize you for a question, and we got here at least one more speaker, and then we'll
Mr.
see
Chairman,
what we're going to do.
a lot of this is proposed to be confusing. Back during the day, Georgia Power wouldn't even go to the rural community. Now you take the pig, now you want to gut him. You know, I'm talking about the EMC. They served the need because Georgia Power wouldn't go out and serve the hinterland.
Do you have a question for the speaker? We'll have discussion of the bill here later, but let's let these folks be heard. If you've got something from Ms. Coyle.
No, I ain't got nothing important,
No,
Mr.
you've got
Chairman.
something. No, it's important.
I ain't got nothing important.
No, you've been here a long time, and you got a lot of institutional knowledge, so we value your comments when we get to that point of the situation. All right, Ms. Patty Durand. I'll tell you, before you get here, I went to Legislative Prayer Fellowship this morning. They told us to remember always to turn the other cheek. You are a candidate for the Public Service Commission.
No, sir, I'm not. The
You're
election
not?
was canceled in 2022.
Okay.
I want to
You-
correct Bobby Baker. The last time anyone voted for a public service commissioner was 2020.
Okay, are you a candidate for District
No,
6
I'm
or
not.
District 46? We've seen you
I'm not a
calling
candidate.
for challengers in those two districts.
No, sir, I'm not a candidate. I'm not
Do
running.
you have views on this bill?
Yes, I have some handouts for the commission, if I may give it to you.
You're going to need to, you had to have those in our office before noon yesterday, but just put them on the table up here. If somebody wants to get one on the way out, they'll be free to.
My name is Patty Duran, and I run an energy consultancy called Cool Planet Solutions. Before that, I ran a nonprofit in the energy space for 10 years called the Smart Energy Consumer Collaborative. We did research on consumers and the smart grid. Before that, I worked at Georgia Tech for a year on smart grid topics. So this handout that I have for the committee is to show a Georgia Power bill, a residential bill, with 1,200 kilowatt hours that month. And it does not show rates, it does not show tariffs, it does not show surcharges. And what I want the committee to see on this bill is that there's a lot of information that's missing. And so that allows Georgia Power to make claims like our rates are 15% below the national average, but what does not get included in the bill are the surcharges, tariffs, and other fees. So it is deeply misleading to say that Georgia Power bills are below the national average when the residential bills are not. Only the industrial bills are below the national average because they get the marginal rates that Bobby Baker mentioned. So I have that demonstrated on the bill, on this handout. So if you go to page 2, what you have to do of the handout is you have to go to the Public Service Commission's website to go to their electric service rate calculator, where you can enter in your information and then click calculate, and then the rate calculator will actually show all the details of the bill. And that's where you'll find on page 2 this fuel cost rider that I've circled in red. The fuel cost rider is over $50 this month. That's for 1 month, just for gas. And if you calculate $50 out of this bill, that's about $195. That is a 26% cost on the bill that is not included in the rates. So therefore, that is my evidence to the committee that residential ratepayers pay a lot more than what is advertised as the lowest cost in the country. It is deeply disingenuous. But let's move on to the last page, because what I really want to share with the committee is that since the Consumer Utility Council was repealed in 2010, and I know we're not here to discuss that legislation, and thank you for passing it out of this committee, residential rates have increased 57%, almost twice the rate of inflation over that period, which was only 31%. And I have the sources below the table. And this is 2023 data. I don't have 24 data because the EIA, the Energy Information Administration, doesn't post last year's data until October the following year, so I won't get that data till October. So this does not include Plant Vogel's rate increase. So if you look at number 2 on this last page, during that same time period, that residential rates increased 57%. Industrial rates, or what Bobby Baker refers to as marginal, only increased 6%, far, far below the rate of inflation, which I see I forgot to update on the table. It should say 31.6%. So that is one example of how that Georgia Power is cost shifting to residential customers from industrial customers. That is a clear example. And I want to make one thing clear. I've worked in energy for over a decade, almost 2. There's no such thing as downward pressure on rates. That is a thing that Georgia Power just makes up. There's not going to be a refund, to Senator Albert's question. There will not be any. In fact, I was surprised to hear the Georgia Power witness talk about the couple of dollars in what they call downward pressure on rates, because that was actually a tax refund from Governor Kemp that they are required to pass through to Georgia Power customers that they are now claiming as part of their downward pressure on rates. That is completely false. It is not because of anything to do with Georgia Power. It has to do with Governor Kemp. And then to the bottom part, number 3, on May 1st of last year, the day after Unit 4, Reactor 4 in Plant Vogel went into service, Georgia Power passed the largest rate increase in U.S. history, definitely in state history, but I couldn't find anything in any state that was larger than a 23.7% rate increase for one unit of one power plant. Let's just throw both units in there. And since then, since that enormous rate increase, residential disconnections have soared over 30% from the prior year's number. And I have a little snippet here of the disconnect report highlighted in yellow, so you can see that about 20,000 people get disconnected. Those are households, let me correct myself, not people, every single month from Georgia Power for inability to pay. Almost 200,000. It would have been 200,000 if Georgia Power hadn't done a moratorium because of Hurricane Helene. And that is almost 10% of their customer base, or 10 times the national utility disconnect rate of 1%. We have a very big problem with residential rates in Georgia. In Georgia. And I want to just make sure that you're aware that, that since Commissioner Johnson was appointed to the commission by Governor Kemp in 2021. There's been no election. He's served now 5 years. He's voted for $20 billion of rate increases for Georgia Power customers without a single Georgia voter voting for him.
So is that the one you want to run against?
And Commissioner Eccles has served for 9 years without an election.
You in favor of this bill?
Yes, sir. I would like you to pass this bill to protect residential ratepayers.
Do you think it ought to apply to EMCs and municipalities as well as Georgia Power?
I'm not sure about that. I'm worried that EMCs, one thing that has not been mentioned, EMCs are a nonprofit. Municipals are nonprofits. The only for-profit entity in this room is Georgia Power. So EMCs have no incentive. In fact, all 5 commissioners pay their bills to electric membership corporations. Georgia Power customers have no representation on the commission, and their bills are all 20% below our rates. I meant to bring that today, but I forgot.
Any questions by committee members? All right, thank you for being here. I'm going to call one more witness because I'm at 12:20, and I have called 7 so far out of the 16. I'm picking at random. John Duke, because you were the 3rd person to sign up. Are you here? Citizen? Well, fortunately, you stood up. You are speaking for the other 6 people that are listed as citizens. Give us your view. If they got thoughts, they should just pass them to us directly.
Wow,
It's
appreciate it.
all on you. Let's hear it.
Yes, sir. A little bit of pressure here.
Yep.
First, I want to say thank you for calling me, and Senator Coward. Yeah, I like the way you run this hearing. It's very, very well run. What is it? CalCert. I'm
Thank
sorry.
you.
CalCert.
You say that because I called you to speak, didn't you?
No, I really do.
We're trying to be fair to all sides and hear it, and
Yeah.
we're honoring every senator that brings legislation before us deserves to be able to present their case. So let's hear it.
Well, I'm a hydrologist. I build FEMA floodplain maps for engineering firms in 26 states. I've got a 1925 home that I have fully electrified. I've put in 9 car chargers for people. I'm not an electrician, but do it for friends and family. And so, sort of as a hobby, I guess I've been following electric markets. And this is so. Just giving that background that I do have a little bit of knowledge. And I've also been to several Public Service Commission hearings and sat through hours of those things. And I'm not a lobbyist. I mean, just doing this voluntarily. And I've watched those hearings, and they've been pretty shocking to me. They're been pretty enlightening, to say the least. And that's why I'm for this bill here, although I think this bill eats at the edge of the real reform that we need. But maybe I can touch on that at the end of my comments here just a little bit, because you asked about a way forward. And the reason I think this bill is needed is because I've been to these Public Service Commission meetings and I've spoken at them, and by and large, the Public Service Commission ignores everything from their staff, expert testimony, citizens' comments. I mean, I don't want to use the word corruption, right? I mean, we shouldn't go there. I'm trying to avoid that, but it feels like these Public Service Commission meetings are show trials, honestly. And Georgia Power is not going to do, to your point, out of the goodness of their heart. And there needs to be the shalls and the musts in the language. It has to be. You're not serious if you don't. So, I mean, obviously there's some senators here who are not for this. The question is why? Who are you fighting for? Your constituents or for Georgia Power? I mean, you really need to ask yourself that. This has nothing to do with partisan politics, does it? I don't think so. I mean, you don't even know who I am. You don't know how I vote. Heck, I'm probably more conservative than most of the Republicans here, no matter how I vote. I mean, but this is why this bill needs to go through, because I've seen these Public Service Commissions. Their own staff told them to abandon Plant Vogtle, like South Carolina did. South Carolina literally buried $6 billion in the ground because they cut their losses and walked away because the plant could never pay for itself. And by the way, Plant Vogtle will run for 60 years, full blast, and on the last day of its operation before it finally retires, it'll finally pay for itself. Maybe. And so the Public Service Commission was told to abandon this. This is just an example. But if I may, I don't want to take, I'm sorry if I'm taking too much time. If I may, I wrote an op-ed of what I think is real reform. And I would just like to read part of it. I won't read the whole thing. But this is what it says. I don't know why the Public Service Commission does not seem to have the people of Georgia at heart. But what I do know is that the world is transitioning to clean energy due to affordability and reliability, and the race is on. For example, in Texas, Red State, Texas, oil drilling, Texas, the Electric Utility Council, Reliability Council of Texas, ERCOT, runs an island grid that depends very little on interstate transfer of power, even during times of peak demand. They request bids from power supply on a given day, and power producers send them in according to how much they can provide at a given price. ERCOT stacks the bids from cheapest to most expensive until they fill the quota. Then the power producers are paid the same price as the last electron, no matter who bid what. This process, called the uniform price auction, makes the grid work on performance and not on how much money was invested in a particular power source. They let the power providers figure that out. Since the fuel source for renewables is free, the profit margin for a renewable energy company is high, even at a lower bid price than what is offered by a fossil fuel plant. So I won't keep going on in my whole op-ed, because I'm really, in this op-ed, also trying to advocate for the renewable energy. But the point of the op-ed is clean energy wins on economics, but this is the reform that we need. Take away all subsidies, take away all subsidies to all power sources, and let the free market truly reign, if that's what you believe in. And at the end of the day, clean energy will win, and so will the consumers of Georgia. Thank you.
Mr. Duke. Appreciate you being with us. Last speaker, I realized the EMCs have been mentioned here, and they've got an amendment that directly affects them. I think they have a chance to be heard. Mr. Curtin, if you could try to hang in here for just 2 or 3 minutes. No, come on. I'm trying to wrap this up by 12:30 and vote on this one so we can do another one, but I need to hear your viewpoint both. Do you think these rules ought to apply to Georgia Power, and do you think they ought to apply to your EMCs?
To directly answer your question, Chairman, hi, I'm Kevin Curtin with the Georgia EMC. Just to introduce myself, I represent the 41 electric co-ops in the state of Georgia. We do not have a position on their underlying bill, Senate Bill 34, although we are opposed to the amendment, and let me explain why. It is very much having to do with our structure. For almost 90 years, this body has trusted the members of our co-ops to elect board members to set our rates, terms, and conditions. That process has worked extraordinarily well. Our rates are extraordinarily competitive. Our reliability is second to none. Having a law imposed on us on this particular issue takes away our board's authority to make decisions on behalf of the co-op. Therefore, we are opposed to the amendment. We believe that trust, which has been embedded in our boards for 90 years, should remain with our boards. I will also point you to 46.311, which is the code section you're trying to amend, already essentially requires us to treat similar customers in a similar manner. So that's already the law. And we followed that law for many years with no problem. Last thing I mentioned is, are we solving a problem that doesn't really exist? Of the co-ops that serve, the 41 co-ops that serve Georgia today, 4.4 million Georgians, they serve one data center that would fall under this bill. One.
As of now?
As of today, correct.
All right. Thank
I'll
you.
be glad to answer any questions you may have.
Thank you. Senator Huffstetler, will you just do a quick wrap-up, and then we'll see if the committee wants to move on your bill.
So right after the Consumer Utility Council was defunded in 2008, as we've talked about, there was another bill that passed in 2009 that allowed a financing method that had surcharges. I know there was a statement that they're not allowed to charge until it goes into service. This actually did. The legislature intervened and allowed it to pay interest, profit, and taxes on the profit. It's supposed to end in 2017, but continued until now. And in addition, we've got the 60-year mortgage on it for the residential and small businesses. Now, the profit on that was supposed to be $5.8 billion when Vogtle was built. Because of the cost overruns and the delays, the profit actually doubled. I don't know where I've seen a system in this country where you get more money for being over budget and behind schedule. But that's, with the add-on, that's what it was. And so we then got involved. I know some of the others, including our previous chair of appropriations, told people outside the legislature and in that was part of the worst bill he had voted for. Others said similar things. So we passed in 2018 Senate Bill 355 that put a sunset on that financing mess. It was a way of letting those guys kind of make a statement, yeah, maybe this wasn't the best way. But, and I know Senator Albers talked about the profit on Georgia Power, which is the majority of the profit of Southern Company, but it was a double-digit increase to $4.4 billion, which came from our ratepayers with multiple rate increases. Again, we've got the 1,000 megawatts that they're paying for that's going to be used. We've got the 3,300 it was talked about. And I know people have beat up on the PSC, and they've frustrated me at times too, but I want to say that some of this stuff was inherited. I think Chairman Shaw is trying to address this. I believe they're seriously working on this right now, but I do believe, as in the previous bills, the legislature has a role as well in this, in protecting our citizens, as we have had bills in the past involved in it. So I'd urge you to support a simple bill that simply says the cost incurred by data centers will be paid by data centers. For those of you that vote no, I'm going to ask, what's your plan? Georgia, a state that prides itself on low cost and low taxes, is now number 4 in residential bills. Should we wait until we're number 1? This bill does not cost Georgia Power a penny, though. It just codifies into law where the cost would come from. It's certainly within the legislature's purview to set parameters around energy. And this does not set rates, but it does provide protection from costs being charged again to our residential customers and our small businesses. With residential power bills, we're now, as we've said, in the five highest in the country. Our citizens are depending on you to protect them from these costs, so I'll ask you to support this bill. Thank you.
Do you have an opinion as to the amendment?
I'm not the expert on the EMCs. I've heard statements both ways. I guess I probably need to be neutral on that at this point. I'm concerned of it, what it might do to the underlying bill, but I would say I'm probably neutral on it overall. I'm just not, and actually haven't seen it as a whole either.
Senator Dolezal, you're recognized for a question.
Thank you, Mr. Chairman. Thank you, Chairman. I'm wondering if line 21 is unintentionally doing what the gentleman from Georgia Power indicated was his concern, and that it would allow, in the cases of large CapExes for new facilities, the sole placement of that cost on the data centers. And I'm wondering why the bill doesn't speak only to the pro rata percentage.
Well, as far as the data centers, we were told that 80% of the costs coming were going to be from that data centers, and that's why we were looking at them as a whole. So, I mean, if I could blow things up and have a whole new rate structure, I would do it. But I was really trying to protect the consumers from the biggest major costs coming on board, I guess.
I understand what you're trying to do. Do you understand? I'm not sure if you caught my question, though.
Right. You're talking. Explain it. Your pro rata. What you're saying.
I'm saying that there's an or proposition in here, that it's either the charges need to be recovered solely from the data centers or pro rata based on electric demand. I'm curious what the scenarios are where it wouldn't always be, and why it wouldn't always just be pro rata demand, and when it would be solely. Because if the pro rata is 100, then it's 100, and then that gives you a path.
So what's your recommended change to the language there?
I would probably need to think through it a little bit more, but I just want to flag that for you. The second thing I wanted to ask is this 100 megawatt or greater metric that's on line 26 and 27. What percentage of data centers do you think that captures? In other words, What's the scale that this would capture? And if the concern is data centers, how did we land at that 100? If that's, obviously that's a massive one. That we heard testimony.
Right, I think it substantially gets all of them. I think we were trying to have a number that
Okay.
would capture pretty much all the data centers.
I think I can answer your pro rata question as I understand it. The OR says they can either solely collect the cost from the data center, or they can take it pro rata, and perhaps if they're not using, 100% of the new cost, it would be fair, but it gives them the option to go one way or the other. And I guess that would be the choice of the provider. Senator Summers, I'm going to recognize you to discuss, well, we'll just wait. Let's do first things first. Is there any motion by a member of the committee, either do pass or do not pass for this bill? I got a motion do pass from Senator Albers, second by Senator Sims, and this is a motion to do pass substitute to SB 34, LC 55046-S. Before further discussion, would you like to propose your amendment, Senator Summers? You don't have to, but you can.
Mr. Chairman, members
This
of
is
the
in our
committee.
folders, and we'll label it as Amendment 1.
Amendment 1.
Nick, I need you to get to the podium because we're going to have to ask you a little explanation.
The simple amendment is, as we keep saying in this committee, we're here to protect the consumer regarding data centers. And we had a conversation today, is that data or data? Either one, we're going to protect them. We're going to protect across the board on data centers. And that's what this amendment's about. And to make sure the code sections are right, we've asked our legal counsel, Nick Tate, to explain the amendment. If you will, Nick, please.
Certainly. So this amendment would take the language on lines 13 through 27, and it would create a new section of the bill that would insert this language as a new subsection to Code Section 4611.3 with a couple changes. On line 13, notwithstanding the provisions of Code Section 46.311 would be switched to notwithstanding the provisions of subsection A and B of this code section. Electric utility on line 14 would be replaced with electric supplier approved or allowed to go into effect under code sections 46.225 or 46.226 on lines 19 and 20 would be replaced with of the electric supplier. And then lines 13 through 27 would be replaced with the following language. No rates or charges of an electric utility shall be approved by the commission or otherwise allowed to go into effect under code section 46.225 or 46.2526 unless such rates or charges comply with the provisions of code section 46.311.
All right, now talk English to us. What does that do? This is our legal wonderkind of our committee here. Nick is wonderful. He's been with us for a couple of years, and he knows how to put into the code the language that we're trying to tell him colloquially. Am I right that this makes the same rules while you're taking the same language, creating a new code section that it applies to EMCs now?
Yeah, that's right. It's taking the current language and putting it in a different chapter that applies to all electric suppliers.
Okay. And am I right that this does not put the EMCs under the supervision or control of the Public Service Commission?
No, it does not.
Okay. It's the state legislature by imposing the same standards on all utility, power providers.
Right, it's just making the new language applicable to all electric suppliers.
Okay. Any questions for Mr. Tate? All right, then we will first deal with the amendment. Is there a motion for Amendment 1?
Motion.
I got a motion proposing Amendment 1. Is there a second to that? All right, there's no second. So we will deal with the underlying bill. The motion is a do pass by substitute, SB 34, LC 55046-S. All in favor? Raise your hand. What, you got discussion? All right, let's hear it.
Thank you, Mr. Chairman. We had a couple of questions, one by our citizen and one by the author of the bill, and I wanted to address both questions. First question is, why would we vote no on this bill? And for me, it's not what we're trying to do in this bill. It's the fact that we continue as a legislature to delegate authority and power to the PSC, and then when we don't like that decision, we go and try to change it. And I think that's the case here. We saw it with, I think the last time I remember delegating powers to the PSC was pole attachment fees. And maybe we've done it since then, but that's the last one that comes to mind. And I fought diligently against it in committee and on the floor and lost that battle. And then many people came that were in favor of shifting that to the PSC and didn't like the decision that they ultimately made, which I did like the decision they made. And again, it's just the fact that we're giving the PSC authority, and then we're coming back and saying, all right, we don't like it. We're gonna overturn what you're doing. And I don't like that, number one. And then two, the author of the bill said, what is your plan? Well, my plan is, if we're going to continue to give authority, well, number one, I think we should quit giving authority. I think we have a better process here in the legislature. It goes through 2 chambers. It goes through 2 committees in each chamber, and it goes on the floor. There's no better process than that. That is the most transparent and heavily vetted process that there can be, and it is certainly better than the process at the PSC. So the plan, I would say, is we quit giving authority away at this level. And that's the end of my discussion.
Other comments or discussion? All right. All in favor, raise your hand. 1, 2, 3, 4, 5, 6, 7. I'm counting 8, Paige. Am I right? All right. All opposed, raise your hand. 1, 2, 3, 4, 5 opposed. So your bill passes committee. We'll move on to the Rules Committee. Do you have the energy left to hear your second bill on the agenda? Yeah, I wish I was that clever to be intended. No, that was just a Freudian slip. All right, I'm going to give you just a minute as the crowd clears out. We're going to be here in Senate Bill 162. It's LC 520744. Yes, birthday boy. Senator Gooch, so glad to have you. We're not going to make them sing. Should have while we had all the big crowd here, the entire choir. But happy birthday to you. I don't think I had your mic on.
Number 4.
You're talking about what you're going to do tonight to celebrate.
While we're waiting for order to be restored in the room, I'd like someday when we have an hour to kill for this body to have an open discussion about how we got to where we are with all this energy policy in Georgia, for the history of it. One, we shut down perfectly fine running energy plants. Coal plants are being shut down across this country. There's a federal policy, depends on who's in Washington, on whether we should have solar panels everywhere, whether we should have nuclear power plants everywhere or not any at all. We're being forced to close coal power plants. Seems like if we'd have kept those coal power plants running, our cost of energy would be lower today in Georgia. But some of the people that testified for this bill today were against coal power plants, and they're against solar, nuclear power plants as well. So I feel like nobody has a strong plan for where we should be in 50 to 100 years down the road. So I'd love to have that discussion with the
I
experts.
agree. That's something we spent a lot of time last year or two looking at how we're going to power up all these electric vehicles as well.
Correct.
So it kind of blends in. That's part of our job. So we'll see if we can find all that extra time.
All right.
Maybe not
on
going to be this
crossover day.
week. Senator Huffstetler, the
Yeah,
floor is
and
yours.
I'll try to be quick on this.
This one is a much simpler bill. I can
For
tell
a
you
couple of
that.
reasons, though, is I'm actually not going to request for a vote today because in working with the Composite Medical Board and the Georgia Hospital Association, there's a couple of things we want to do to it. But let me go to what we've been working on. We've been working on this for over a year. Right now, you've got a system with physicians, physician assistants that the Composite Medical Board has had a leadership change in the last year, and I think we're working on getting into the modern era. I think they're doing a great job. As it is now, you might be 7 months getting credentialed somewhere. Sometimes I've seen it longer than that. When I actually went to work at a hospital across town, I did it in 3.5 months, but maybe I've got connections. I don't know. But this system that they're going to put in place has been proven in other states. It works. Pretty much everything I do is stolen from one of the other 49 states, but it works in other states. The Composite Medical Board's been very proactive in trying to get it in place, and we feel like that they will have somebody credentialed. There's licensing, which they do, and there's credentialing, which the hospitals or other healthcare providers do. They do the licensing, so I need to keep my terminology right on that. But we think the licensing will be done within 30 days, and I really think it will be within 2 weeks at their point. The other substantial change we're trying to do is, and we've already tested this out with the medical students, the dean of the Northwest Georgia campus. You know, these medical students go in a hospital, they send all their paperwork, their transcripts, everything, and then they go to the next and do the same thing. They do it 15 times. It's crazy what we're doing. And nobody's sat down and said, why are we doing all this? All that data will be online. And one other problem with the previous system is it didn't kick out if you were deficient in something. Somebody would sit around for weeks or months and call, what's going on with my application? They actually had to manually go in and try to figure out what was going on. This system will let you know of any deficiencies that are there. I think they're really putting a good system in. But we've done this where now our medical students, as guinea pigs in this, are credentialed wherever they go now. And it was costing them hundreds of dollars per hospital to go through this process. So we know it works in this state on a much smaller scale. The biggest change we're looking at is that you would be, and we're certainly wanting to do this with the nurses too, but they're under the Secretary of State, and I think Chairman Tiller and Larry Walker working more on that side of it, where you would be credentialed. If you're credentialed at one facility in Georgia, you would be credentialed at all facilities in Georgia, but we would also allow the hospital to have additional requirements if they want to. And I think I've heard from the Composite Medical Board, they could even build that into their software, that the hospital could have their own unique requirements. So we've done this with the students already. We're going to move from, as it is now, you talk to them from out of state and say, well, I'll see you in maybe 7 months. Well, it's hard to hire people that way. It's a huge workforce issue for us. Somebody goes on pregnancy leave and somebody tries to get credentialed there and the baby's 3 months old before they get credentialed. It's not really working in that manner either. So I want to applaud the Composite Medical Board for their hard work on this over the last year. Dr. Gross is not here, but he's one of the physicians that's on that board, and he's certainly been instrumental in making this change go forward. I've got some changes that we need to make to it in a couple of lines, and I'd like to obviously get this moving, but I don't feel comfortable with it today. And I know
running out of time.
I know, and the Georgia Hospital Association, I think maybe is here. I know the Composite Medical Board's here, and maybe they can speak to it.
Nobody has signed up to speak to this bill but you.
Okay.
If somebody's here that wants to, though, I'll give them a chance. Come on up and get ready. Chuck, you go ahead and finish your comments.
I'm basically finished if they want to talk, and I'll,
All righty.
all right, if there's any questions, I can answer those two first.
If you'll take the podium, identify yourself and give us your views.
Thank you, Chairman, members of the committee. My name is Ryan Miller. I'm with the Georgia Hospital Association. We just wanted to support Senate Bill 162, thank the author for his hard work. We appreciate the effort to streamline the licensure process.
Any questions? All right, thank you for being here. Yes, sir.
Hey, I'm Jason Jones, the Executive Director for the Medical Board. We have been working with the Senator on some changes to it, but for the premise of it, it's good because we are moving in that direction where we're going to license quicker, a brand new system that's going to make things more streamlined. And the credentialing side, we don't do that, but we believe we can build it into our system to where everything will be a smoother, one system, go to one spot to get that. So I think it'll speed up that process. We just got to tweak it just a bit. But we're moving in that direction to make things quicker and more efficient. So I think we'll get there, and this is just part of that push to get there.
What's credentialing mean? Is that licensing, giving a medical licensing?
So credentialing is when a hospital takes all that information, such as licensing, schooling, certifications, and they compile that together to say they're good for that specialty at a hospital. We don't do that. We just do the licensing part, making sure that they have the education and credentials for the licensing. But hospitals go a little bit more in depth as far as a specialty that goes.
So this isn't like giving somebody hospital privileges to see patients at your hospital, or is that what we're talking about?
So that's what we're talking about.
Okay.
Yes, sir. And we don't do that at the medical board, but we're hoping we can contribute to it.
All right. Senator Albers has a question for you.
Thank you, Mr. Chairman. It's more of a comment for those of us that haven't been fully aware of the Composite Medical Board. For many years, they were a bit challenged. We were not getting the type of service innovation. It was really slowing things down. Since our new executive director, Jason Jones, has taken over, it has been a 180-degree shift. Things are on the right path forward. So thank you for what you and your team are doing now. My constituents are very happy by the work you're doing.
Thanks, sir.
Other questions? Senator Lucas, you got any views on this one, brother?
No, sir.
All right.
I'm from Macon, you sure?
We thought you must.
Born and raised.
We thought you were in Senator Albert's district there for a minute when he was complimenting you so much. All right, nobody else being signed up to speak. Are there any other questions for the author?
Can I make one other quick comment?
Tell me what amendment you wanted. What is it? A very small change? What
Well,
is it you're looking for?
we've got to take out, they do protocol agreements with nurse practitioners, but they don't really license them. That's done on another board, so I need to take them out.
What line are you talking about?
Well, in a couple of places, we've got them listed, and I got to go back. So I had a sub that actually had that in, but I didn't get it to you, so I didn't want to do that today.
Okay.
But you'll see them on the first page listed as protocol agreements for or licensing for advanced practice nurses, and we needed to take them out. We need to change that line 12 from credentialing to licensing, because this is the licensing part. And I mean, we could fix it in rules if you want to do that. It's just a few technical things. It'd be the commission. One other comment I want to make real quick is we had the hospitals, the CEOs really want this, and they said, we'll change our bylaws if we have to make this work, because we can get people almost immediately. No hospital had to change a single bylaw to make it work for the medical students.
Okay. I'm going to recognize Senator Summers for a question.
Senator Brass.
Senator Brass, I'm sorry. He changed his mind.
I was just going to walk through some procedural stuff. If it's no questions, so.
Okay.
But as far as timing goes, if this bill were to move out today, it would get reported out of committee tomorrow, second read on Friday. We would have time to do, to move it in standing rules. We could make changes there. if the committee were in agreement to move the bill along. And I only suggest that if the committee does want to move it along, there is time to do it, and then it doesn't clog up your committee, Mr. Chairman.
All right.
And I do have the changes in red here, but there's half a dozen of them. I don't know if.
Okay. Pass them up here.
Okay.
Tell you what, we can probably make it simple. We can take an amendment from the committee to change that credentialing to licensing on line 12. That'll get you going. You also wanted to take out the date there of no later than July 1st.
Well, that's what the Composite Medical Board wants to do. I'm
They
trying to
didn't
look
say
some
that.
goals,
They
but
just-
I'm okay with that.
Okay. All right. We will accept an amendment from Senator Albers here when the time comes. And then you can either deal with it in Rules Committee or else on the floor to make your other
Okay.
changes. We'll at least get you where we know what we're talking about. As I understand it, you would want to change the word credentialing to licensing at line 3 and at line 12, just to clarify that nomenclature, right? Mm-hmm. Okay. So what's the pleasure of the committee on the passage of the bill? I got a motion do pass by Senator Albers and a second by Senator Anderson. Okay. And now, would you like to propose your amendment, Senator Albers? Is that at line 3 and 12?
3 and 12, requesting credentialing with license.
All right. Is there a second to that amendment? Seconded by Senator Summers. All in favor of the amendment, raise your hand. Any opposed? All right, so we got you partially amended anyway, so we're at least directing it the right subject matter. All right. Any further discussion on passage of this bill? All right, all in favor of the do pass Senate Bill 162, that's LC 520744 as amended, raise your hand. And that appears to be unanimous. Thank you. That was very quickly done, a lot more efficient than your last one. But no more important to certain people, right? Senator Harbison, you have this room for committee, and I think we are just about to encroach on your time. I got 1 minute left. What is your committee? The yeah.
We got the state institution annual bill to pass.
Okay.
With all the properties, it's got one important issue in there as well. So.
Okay. Are you willing to cede 5 minutes to me for the Senator
About
Jackson to
4.5.
present? We're going to give 4.5. Senator Jackson, I wouldn't do that without the permission of the dean, but I've noticed you sitting here the whole time.
Yes,
And he's gracious enough to give you 4.5 minutes to present Senate Bill 142. We'll have to take testimony later, but at least educate us because we're on a time crunch.
Yeah, thank you, Mr. Chairman, and thank you also, Mr. Dean, for ceding a bit of your time. We've heard this bill actually in brief in this committee last year, but what this bill does at its heart is it creates a pathway for any individuals who were trained as medical physicians internationally to be able to have opportunity for a license here in Georgia. It is also geared towards making sure that those physicians who do come are able to work in places where we need them. So it's specially and specifically tailored for folks to only be able to have this limited license in a place that has a high need. So they have to be in a rural area, a place where there's underserved. So it really is geared towards, and this came out of a recommendation from the Rural Health Committee Study Committee that we did, I guess, a year and a half now ago, to try to help make sure we can get more physicians online in places where we need them desperately across Georgia. It's a two-tier process. So the first 2 years, it's a limited license or it's a provisional license. Now, mind you, you have to have graduated from medical school. That's absolutely essential. You also have to have worked. You have to have been licensed and worked as a physician in your home country, in the country that you came from. And we've confined it so that in the original bill that we had last year, we weren't very clear about how recently you would have needed to work. So we've narrowed that and said if you need to have worked within 3 of the last 7 years. So we've narrowed it so you can't say I was a physician 10 years ago and I want to come and start working tomorrow. We've said you had to have worked within the last 3 or 7 years. And then you can apply through the Medical Composite Board for a provisional license that would only allow you to work in these places where we need them. And that, of course, you'd have to be hired there. The institution would have to hire you and agree to take you on. They'd have to have the capacity to be able to supervise you, of course, in that process. And then after 2 years, while you're doing that, you would have to pass some medical exams. So there's step 1 and step 2 medical exams. So there's a process. There's some safeguarding in place for us that will help make sure and ensure that these folks are up to standards, if you will. And then their second 2 years is kind of what I think of. You know, I have a brother-in-law who did his medical degree, did residency, and then in order to get his loans paid back, he had to go and work out in rural Indiana, and he worked for 4 years in rural Indiana, and they paid all of his medical loans, right? So that's what I think of this next second years. So the first 2 years, you're getting your supervision, you're taking step 1, you're taking step 2. And then the next 2 years, again, you have to be in a place where we need you. So you need to be at a federally qualified health center, or you need to be in a rural hospital. You need to be in a place where there is need. And you serve there for 2 more years. And that's kind of the commitment to Georgia, right? Saying, you know, we created this process for you. We've helped kind of smooth this way. So we want to make sure. And what we also know, and this is true certainly for my brother-in-law, is when you keep a person in a place for about 4 years, that's often long enough for them to put down roots and really build a family there. And so, you know, my kind of secret hope here is we expose people to these smaller little areas that needed a doctor, and they find it to be home, and they stick around so that we can continue to really fill in this gap and this need that we have for physicians. So that's the general overview. You know, of course, there are details here that I'm happy to go through if you would need me to, but that's the overview.
So it's essentially a provisional type license to practice medicine in Georgia?
That's right. It's a provisional license to start while you're getting the rest of your credentialing. So you are having to take these exams these are national exams, right? So step 1, step 2. And while you're also working, you take your step 3 before you can get a limited license. And then after that, you can actually apply for a full license. So it's not an indefinite, like forever, you have to be in this limited position. You can then apply for a full license.
So it's 2 years to start with, and an additional 2 if you go to a highly, needed area.
Yeah, you actually need to be at a high needs area both times.
Okay.
So it's really 4 years of being in a position, in a place where we need you. But there's additional supervision requirements on that first 2 years in particular.
I know we have a number of people signed up that would like to be heard on this. Just looking roughly at my chart, it looks like about 5 or 6 people. So we're going to have to postpone action on this. But thank you for presenting it to us. Committee members, don't throw it away. You want a question? All right. Senator Summers has a question. Might have been a smart aleck question just to me.
No. I'm just curious, people in the audience, raise your hand if you support this bill that Senator Jackson has. I'm just curious how y'all are here for. And those that don't support it, well, that's a good sign.
All right.
Thank you. I'm sorry, Mr. Chairman.
Thank you. With that, we are adjourned. We still need your RSVPs for the dinner tomorrow night. Please let Paige know.